National interest waiver versus national interest exemption. What's the difference? Welcome to Voice of Immigration. I am John Veely, immigration attorney and CEO of Online Visas, the intelligent immigration platform. Here's what you need to know. The National Interest Exemption, or NIE, is for certain business travelers, investors, treaty traders, academics, students, and journalists who may qualify for national interest exemptions under the presidential proclamation covering travelers from the Schengen area, which is Europe, United Kingdom, and Ireland. Qualified travelers who are applying for or have valid visas or ESTA authorization may travel to the United States even as the proclamation remains in effect following the procedures below. Students traveling from the Schengen area, the UK and Ireland, with a valid F1 and M1 visa do not need to contact an embassy or consulate to seek an individual national interest exemption to travel. Students seeking to apply for new F1 or M1 visas should check the status of visa services at their nearest consulate. For those applicants who are found to be otherwise qualified for an F1 or M1 visa will automatically be considered for a national interest exemption to travel. Business travelers, investors, academics, J1 students, journalists, and treaty traders who have a valid visa in the appropriate class or who are wanting to apply for a visa for national interest should contact the nearest U.S. embassy or a consulate before traveling. If a national interest exemption is approved, they may travel on either a valid visa or an ESTA authorization as appropriate. The Department of State also continues to grant national interest exemptions to qualified travelers seeking to enter the United States for the purpose of related to humanitarian travel, public health response, and national security. National security can mean financial hardship to an employer. It is important to show how the beneficiary cannot adequately perform the job remotely and the evidence of how it impacts the petitioning company if they're not in the U.S. to perform the job. These decisions are made in a discretionary basis at the U.S. consulate and can be difficult to obtain. While these situations are waivers of national bans, they are not national interest waivers. These are green cards under the EB-2 category that waives the labor certification process in the national interest. These permanent residency visas are available for people who meet the underlying criteria of the EB-2 green card, which are either an advanced degree, which is either a master's or doctorate degree, have a bachelor's degree plus 5 years experience, or possess exceptional ability, which is where you can establish two of various listed criteria. The next step is to prove national interest, which is substantial merit and national importance. This basically means the endeavor is significant and has impact. National importance does not require national scope, however. This is proven by statements by the beneficiary. In sum, what are they doing and how will it make a difference? From business plans to proof of concept to opening for business and producing goods and services. The further along and bigger, the better. The second prong is well positioned. It is a stronger case for a CEO or a higher ranking person, but having an impactful role in the company can also work. Proof can be education, skills, knowledge, and a record of success in related efforts. The third prong is benefit to the USA. This is where we prove that the waiver of the labor certification is better than waiving it. One of the best arguments here is that the person owns the company, so they cannot do a labor certification, but they created a number of jobs for Americans. If you would like more information on these two vastly different but similar sounding visas, go to onlinevisas.com and schedule a strategy session. We can discuss how to file your case. Our lawyers will be processing our cases using the Online Visas Intelligent Immigration Platform, the most effective and efficient visa building tool in the industry. We build 20 to 30 page briefs that identify issues up front and answer them with leading case law and other authority as if we were answering an RFE. The beautiful magazine-style brief is supported by evidence we review, analyze, and make suggestions and other documents we create on our platform. If you like this content, please click like and share. You can stay up to speed by subscribing to our YouTube channel or follow us on LinkedIn, Facebook, Quora, Instagram, or Twitter. I'm John Veely, CEO of Online Visas, the intelligent immigration platform where we deliver dreams.